Good morning, dear students. Today, under our Unit 5 of Employees' Relations and Labour Laws, we are going to discuss Maternity Benefit Act 1961. An effort to get maternity benefit legislation, which was enacted in the country, was made by N.M. Joshi in 1924. That year, he introduced a bill in the Legislative Assembly prohibiting the employment of women in factories, mines, and tea estates immediately before and after confinement, and also making provisions for maternity allowance by local governments from a maternity fund. So the maternity fund was to be raised by subscription from employers. That time the bill was rejected by the assembly as the government of India thought that the time was not sufficiently ripe for such a measure. But then later, um, Maharashtra, then Bombay, took the lead by enacting the first Maternity Benefit Act in the country in 1929. Then it was followed by Madhya Pradesh, then like Madras, Mysore, Uttar Pradesh, Kerala, Punjab, and so on and so forth. So, a full-fledged Maternity Benefit Act, the first central measure which was taken for maternity protection was the Mines Maternity Benefit Act 1941. And the act which was applied to mines provided for payment of maternity benefit to women workers at that time. So, but then it was Central Maternity Benefit Act, 1961. It was a repealed and replaced in all the states which earlier were having their own maternity laws. So, Maternity Benefit Act 1961 regulates employment of women in certain establishment for a period before or after childbirth and provides for maternity and other benefits. Such benefits are aimed to protect the dignity of motherhood by providing for the full and healthy maintenance of women and her child when she is not working. The act is applicable to mines, factories, circus industry. Uh, it is applicable to the mines, factories, circus industry, plantation shops, and establishment employing 20 or more persons, except employees covered under the Employees State Insurance Act. So, employees who are covered by State Insurance Act, they will not be covered by this particular act. So, it can be extended to other establishment by the state government. The Central Industrial Relations Machinery, that is CIRM, in the Ministry of Labour is responsible for enforcing this act. CIRM is attached office in this of the ministry and is also known as Chief Labour Commissioner. The objective of this act is um, uh, to protect the employment of women during the time of maternity and entitles them to full paid absence from work to take care for the child. The amendment in 2016, it seeks the increase of maternity leave period from 12 to 26 weeks in all establishment, including private sector. So, talking about the provisions, there are many provisions uh, which have been given under this act, but primarily we'll be discussing seven provisions. So, first is no employer shall knowingly employ a woman in any establishment during the 6 weeks immediately following the day of her delivery or her miscarriage. Also, no woman shall work in any establishment during the 6 weeks immediately following the day of her delivery or her miscarriage. Then, second provision is that every woman shall be entitled to and her employer shall be liable for and payment of maternity benefit at the rate of the average daily wage for the period of her actual absence, that means immediately preceding and including the day of her delivery, and for the 6 weeks immediately following that day. So the average daily wage here means that the average of women wages payable to her for the days on which she has worked during the period of 3 calendar months. 3 calendar months means 90 days. Immediately preceding the date from which she is remaining absent on account of maternity. Um, Then no woman shall be entitled to maternity benefit unless she has actually worked in an establishment of an employer from whom she claims maternity benefit. Obviously, if she's not working, she cannot claim maternity benefit for a period of not less than 160 days in the 12 months. That means at least 160 days she should have worked. In 12 months, that means 1 year before, immediately preceding the date of her expected delivery, when she's going for delivery, and that means she should have worked for not less than 160 days. So for the purpose of calculating the days on which a woman has actually worked in the establishment, the days for which she has been laid off, the period of 12 months immediately preceding the date, shall be taken into account. For example, if before going to the maternity leave, she somehow was laid off during the 12 months, so that employer cannot say that that period will not be taken, will not be considered as the, say, working period. No, a provision says that that period has to be counted as a working period. Then fourth provision is that maximum period for which any woman shall be entitled to maternity benefit shall be 26 weeks. That is to say, 6 weeks up to including and day of a delivery, and 6 weeks immediately the following day. No deduction from the normal and usual daily wages of a woman entitled to maternity benefit shall be made by any reason, only of the nature of work assigned to her by the virtue of provision, or the breaks for nursing the child is allowed to her under the provisions of Act. That means she can take the nursing breaks in between to nurse her baby. Then the next provision is, if a woman works in any establishment after she has been permitted by her employer to absent herself for any period, during such authorized absence, she shall forfeit her claim to the maternity benefit for such period. Then, if any employer contravenes of the provisions of this Act or the rules made there, under he or she shall be punishable offence with imprisonment or with the fine or without both. And where the contravention is of any provision regarding maternity benefit or regarding payment of any other amount, and such maternity benefit or amount has not already been recovered, so the court shall, in addition to recover such maternity benefit or amount as if it were fine, and pay the same to the person entitled thereto. So these are the main seven provisions which have been given under the Maternity Benefit Act. Now, talking about, say, rest of the provisions that have been given by the, say, as per this particular law. So, first is employment. First is employment or work by women prohibited during a certain period. That means this act also deals with that a female should be working and when she should be prohibited for working. So no employer shall knowingly employ a woman in any establishment during the 12 weeks immediately following the day of her delivery or her miscarriage. Then no woman shall work in any establishment during the 6 weeks immediately following the day of her delivery or her miscarriage. Then third is without prejudice to the provisions of section 6. No pregnant woman shall, on a request being made by her in this behalf, be required by her employer uh, to do to do during the period which is specified any nature of work which involves long hours of standing, or which in any way is likely to interfere with her pregnancy or the normal development of the fetus, or is likely to cause her miscarriage or otherwise to adversely affect her health. Um, then the period that has been referred to in the section 3 shall be at the period of 1 month immediately preceding. the period of 6 weeks before the date of her expected delivery, or any period during the said period of 6 weeks for which the pregnant woman does not avail leave of absence under the section 6. Then second is our right to payment of maternity benefit. So, talking about this, the subject to provisions of this act, every woman shall be entitled to, and her employer shall be liable for, the payment of maternity benefit at the rate of average daily wage for the period of her actual absence. That means the period when she is not working, she will be paid at the rate of average daily wage immediately preceding the including day of her delivery, and for next weeks immediately following that date. So for the purpose of this subsection, actually the average daily wage means the average of women wages payable to her for the days on which she has actually worked during the period of 3 calendar months. That means for 90 months, sorry, for 90 days, uh, um, um, for 90 days the wages that she has been earning will be taken into consideration as the for the average wages, and they will be calculated from the months immediately preceding the date from which she absents herself on account of maternity, or 1 rupee per day, whichever is higher. Then no women shall be entitled to maternity benefit. So there has to be, right, when we talk about getting payment under this act. So first is that female should have been working for not less than 90. That means the average for calculation purposes, average wages will be calculated on the basis of 90 days, and she should not have worked less than 160 days during the entire 12 months before she actually goes for the maternity leave. But if a woman, she has not she has actually worked in an establishment of the employer from whom she claims maternity benefit for a period of not less than 160 days. That is what I was saying, in the 12 months immediately preceding the date of her. If she has not worked minimum for 160 days, then she will not be claiming her right to payment. Then, provided that the qualifying period of 160 days shall not apply to a woman who has immigrated into the state of Assam and was pregnant at the time of immigration. That means if generally because this was applicable to the tea plantations also, and Assam has got huge tea estates and gardens. So this provision was included in the act, that qualifying period for 160 days shall not apply. That means if a female who was working at any other place and then migrated to state of Assam, and she was pregnant at the time of immigration, then this too will be taken into consideration. Then the maximum period for which any women shall be entitled to maternity benefit shall be of 26 weeks. That is to 26 weeks as per new amendment. Otherwise, it was 12 weeks. So, provided that where a woman dies during this period, the maternity benefit shall be payable only for the days up to and including the day of her death. That means till her death, payment will be given to the to her nominees. So this was in under right to payment of maternity benefit. Then payment of maternity benefit in case of death of a woman. Now, let us suppose if a female, she dies. So, if a woman entitled to maternity benefit or any other amount under this act, she dies before receiving such maternity benefit or amount, or where the employer is liable for maternity benefit under the second provision of Section 5, the employer has to pay such benefit to or amount to the person who has been nominated by the women in the notice which has been given under Section 6, And in case there is no such nominee, then to her legal representative. Whosoever will be representing her legally, the amount would be paid to that person. Then payment of medical bonus. Talking about payment of medical bonus, every woman entitled to maternity benefit under this act shall also be entitled to receive from her employer a medical bonus. Uh, if no prenatal confinement and postnatal care is provided by the employer free of charge. That means if a person if there is a female who has been working, so she is entitled to get the medical bonus. That means apart from 12 weeks of her salary, a female worker is entitled to a medical bonus of 3500 Indian rupees. So every woman entitled to maternity benefit act under this act, uh, she shall be entitled to receive it from her employer a medical bonus of rupees 1000. If no, again prenatal confinement and postnatal is provided by the employer. Central government may, from time to time, by notification and official gazette, increase the amount of medical bonus subject to the maximum of 20,000. That means maximum bonus which a person can receive is 20,000. But under the National Food Security Act 2013, pregnant women and lactating mothers are entitled to receive maternity benefit of at least rupees 6,000. So the act further requires that subject to such schemes as may be framed by the central government, every pregnant woman and lactating mother will be entitled to free meals during pregnancy and 6 months after the childbirth through the local Anganwadi so as to meet her nutritional requirements. Then dismissal during the during absence or pregnancy. So, where a woman absents herself from work in accordance with the provision of this Act, it should be unlawful for her employer to discharge or dismiss her during on during or on account of such absence. So, or to give notice to discharge or dismissal. So, the discharge or dismissal of a woman at any time during her pregnancy, if the woman, but for such discharge of dismissal, would have been entitled to maternity benefit or medical bonus, which has been referred in Section 8, shall not have the effect of depriving her of maternity benefit or medical bonus. Then, any woman deprived of maternity benefit or medical bonus or both may within 60 days from the date on which the order of such deprivation is communicated to her, she can appeal to such authority as may be prescribed, and the decision of that authority on such appeal, whether the women should or should not be deprived of maternity benefits or medical bonus, shall be final. Then there are uh, uh, this payment of medical bonus we have already discussed. Now it is maternity leave. When talking about the maternity leave, Benefit Amendment Act 2016, it was passed in Rajya Sabha in 2016 August, and so it came into implementation on March 2017. So under the new law, maternity leave has been raised from 12 weeks to 26 weeks. The paternal leave is also extended from 6 to 8 weeks. However, a woman with already two or more children is entitled to only 12 weeks of maternity leave, and the prenatal leave in this case remains 6 weeks. So, the Act also provides for adoption leave. So if a person, if a female is adopting a baby or is adopting a child, then adoption leave of 12 weeks for a woman who adopts a child under the age of 3 months. That means if the child is below the age of 3 months, she is entitled for 12 weeks leave. A commissioning mother is also entitled to a 12-week leave from the date the child is handed over to her. Uh, who is a commissioning mother? Commissioning mother is defined as a biological mother uh, who biological mother, for example, now there are two ladies, let us suppose. One, in case of, this is generally in case of surrogacy. So, for example, a female who is carrying a baby of other female, who is a commissioning mother, she is also entitled to 12-week leave from the date child is handed over to her. So, mm, uh, the baby, the female who was carrying her baby who under surrogacy, when she is handing over the baby to the commissioning mother, that means who is actually the biological mother of the child, is also entitled to receive a 12-week leave. In case where the nature of work assigned to women is of such nature that she may work from home, the employer may allow her to do so after availing the maternity benefit for such period and on such conditions as the employer and the women may mutually agree. Then the Act also further requires an employer to inform a woman worker of her rights under the Act at the time of her appointment. The information must be given in writing and in electronic form. That means through email also. And in case of civil servants, they are entitled to maternity period of 180 days for their first two live born children. Um, Further, every establishment having 50 or more employees shall have the facility of creche within such distance as may be prescribed, either separately or along with the common facilities. And provided that the employer shall allow 4 visits a day to the creche by the women, which also include the interval for rest allowed to her. Then every establishment shall intimate in writing and electronically to every woman at the time of her initial appointment regarding every benefit available under the Act. Now, this Act also grants certain leaves to the female who is going for maternity leave. One is the general maternity leave. Second is leave for miscarriage. So, if a say female, say in case of miscarriage or medical termination of pregnancy, women shall, on production of such proof or as may be prescribed, be entitled to leave with wages at the rate of maternity benefit for a period of 6 weeks, immediately following the day of her miscarriage, or as the case may be, her medical termination of pregnancy. Then, second is leave with wages for tubectomy operation. In case of tubectomy operation, a woman shall, on production of such proof as may be prescribed, be entitled to leave with wages at the rate of maternity benefit for a period of 2 weeks immediately following the day of her tubectomy operation. Then we have a leave for illness arising out of pregnancy. Sometimes it so happens that there might be certain complications which arise during the during carrying a baby or after delivery. Sometimes it may be premature death of premature birth of a child, and and sometimes it is medical termination of pregnancy. So, a woman suffering from illness arising out of pregnancy could be delivery, premature birth of a child, miscarriage, medical termination, tubectomy, and all that. Shall, on production of such proof as may be prescribed, be entitled, in addition to the period of absence allowed to her under Section 6, as the case may be, and under Section 9, to leave with wages at the rate of maternity benefit for maximum period of 1 month. Right? Then this act also gives provision of nursing breaks. Well, every woman delivered of a child who returns on duty after such delivery shall, in addition to the interval for rest allowed to her, be allowed in course of her daily work 2 breaks of the prescribed duration for nursing or lactating the child until the child attains the age of 15 months. So, the Act also gives the provision for nursing breaks. Then we have dismissal provisions for dismissal during uh, absence of pregnancy. When a woman absents herself from work in accordance with the provision of this act, so it shall be unlawful for her employer to discharge or dismiss her during or on account of such absence. Then the discharge or dismissal of a woman at any time during her pregnancy, if the woman, but for such discharge or dismissal, should have been entitled to maternity benefit or medical bonus, as is referred in section 8, shall not have the effect of depriving her of the maternity benefit or medical bonus. Then any woman deprived of maternity benefit for or medical bonus or discharged or dismissed during or on account of her absence from work in accordance with the provisions um, within 60 days of the date on which the order of such deprivation or discharge or dismissal is communicated to her, appeal to such authority as may be prescribed, and the decision of that authority would be final in that case. Then there would be no deduction from the normal and unusual daily wages of a woman who is entitled to maternity benefit under the provisions of this act, and it shall be made by the reason only if the nature of work assigned to her by virtue of the provisions contained in subsection 3 or section 4, or breaks for nursing the child allowed to her under the provision of section 11. So, this was all about Maternity Benefit Act 1961. Hope you have understood it and enjoyed the session. Thank you.